Welcome. Today we're going to discuss the situation many schools are facing with parents using social media and specifically WhatsApp. ISBA, the Independent Schools Bursars Association, have recently issued some pretty thorough and indeed balanced guidance on this, which specifically incorporates input from Farrow & Co., one of the most respected law firms in the UK. Now, this guidance is confidential to ISBA members, but the bottom line is that parents and schools do face a real legal and other risks arising from parental WhatsApp groups. And schools should look at taking a more proactive role in this area. When schools in the UK, and indeed many other parts of the world, consider parents on social media, there are actually three different areas of risk. Firstly, inclusivity. Some parents and specifically teachers with pupils in the school may not want to join the WhatsApp groups. They may feel compromised if they did, or indeed, perhaps they just might be excluded by the other parents. Secondly, there are security and content risks. Group membership may be poorly controlled, groups can amplify misleading information, and occasionally serious issues can arise with abusive comments or indeed bullying. And finally, there's the risk that important new legal implications for parents administering these groups, and even in some circumstances for the school. Now, today we're going to focus on this third legal area, and I'm delighted to be joined by Piers Claydon from Claydon Law, a firm specialising in data protection, to understand more about what parent and school legal liabilities could be around GDPR and WhatsApp, and what schools can do about it. Piers has no connection with ISBA, but has worked extensively in this area. So let's get going, shall we? And as far as you can, perhaps in a one-liner, what is it that parents on WhatsApp groups should be? Could they be a concern to schools from a legal perspective?
Sure. Well, look, you started with a tricky one. One-liner is probably it's going to be a challenge, but I'm up for it. So parents running school WhatsApp groups are likely not only to be breaching WhatsApp's own terms and conditions, but they are also risking sort of potential liability under the UK GDPR law, the data protection law. This could, for example, become an issue if a parent feels information about them, or indeed information about their children, is being shared or used inappropriately. And the reason why this matters to schools in particular is that where schools have been seen to benefit from these WhatsApp groups as a communications platform, they may, in extreme cases, have some liability, even where the school claims to be hands-off.
Okay, so that's really interesting. I wonder if we can just go a little bit further. So how could, for example, an individual parent running a WhatsApp group have any liability under GDPR? That's a little difficult to understand.
Yes, no, I understand. And it's a really good question. So sometimes people see GDPR as relating sort of mainly to companies and businesses and corporations, but actually it can also apply just as much to individuals, just like you and I. So if, as a year 3 rep, I set up a year 3 WhatsApp group, it isn't just something I'm doing for my personal friends and family and contacts. There is actually an exemption from GDPR for just that kind of use for social and domestic purposes. But according to GDPR, I'm collecting data from people who I don't know. I'm doing it electronically. I'm storing it and managing it. I've therefore become what is termed under GDPR parlance a data controller. Now, look, this might sound alarming, but simply means that I need to manage this data responsibly and securely. I should have the ability to share with those parents that data that I hold about them, delete it if they ask me to do so, and have some understanding of what actions I need to take if this data were accidentally to become public through some kind of breach, security breach.
So within IAPS, I'm actually the data controller for IAPS, so I have some understanding of this. But is there actually any problem with a parent being a data controller?
Well, look, in many situations, of course, there won't be, but unfortunately with WhatsApp, the position is a little bit more complicated than that. I've already touched on the fact that WhatsApp's own terms and conditions make clear that it is only designed for personal use. It therefore doesn't actually in itself provide many of the tools that parent group administrators will need to ensure that their data is being managed safely and in accordance with GDPR requirements.
Okay, so I wonder, could you give me a simple example of what could go wrong?
Yeah, of course. So well, let's say that there's been a misleading post on a WhatsApp group. For example, a named child the post says a named child has COVID and shouldn't attend school. So the child's parent asked the WhatsApp group administrator to remove this misleading content. The administrator may not be able to do this through WhatsApp, although the parent has a legal right under GDPR on behalf of the child to ask for that misleading content to be corrected. The parent might also legitimately ask who can see this content. And again, the administrator may not be able to answer that because all the administrator has is a list of phone numbers, some of whom may be possibly anonymous. So isn't managing this data in the secure and accountable way which is required by GDPR.
Okay, so I can understand that why that could be a problem, but in the real world, could there be any real consequences for the parent administrator? It seems a bit trivial, but are people really fined or sent to prison for this?
Okay, so it may sound trivial, but you can see that if there's misleading or even litigious content, particularly around children, which is shared in an insecure, anonymous group, the parent would have every right to be upset, I think. Real damage could be done. And in these circumstances, people who are upset can behave in unpredictable ways. It certainly isn't inconceivable that they could look at legal redress, even if the financial damages are likely to be minor. But to your point, just to reassure folks, breaching GDPR isn't a criminal offence, and so we're not talking here about custodial sentences. But of course, even if things don't go legal for people in a professional role, which many parents are, it certainly isn't good to be seen to be mishandling personal data.
Okay, so that's very clear, and we can understand better the risk to individuals there. But let's look at it, if we may, from the perspective of the school. Is any of this relevant to the school, particularly if the school has had nothing whatsoever to do with setting up that WhatsApp group in the first instance?
Yes, and so there will always be a spectrum of facts here, but let me pose another example. If the school helps to set up it does help to set up a WhatsApp group, or even if it doesn't but directs parents towards those groups that it knows are in existence. For example, a staff member saying, I can't give you a parent's address because of GDPR, but look, go and have a look at Sue's WhatsApp group. Then the school may, under certain circumstances, be considered to be what is called a joint controller of those groups. The school knows what is going on and is deriving some benefit because the parents use the group to connect for school-related purposes. Courts have recently become more open to this type of joint liability arguments. And as a joint controller, the school could be held jointly liable for breaches which have occurred. And of course, the school may, in those circumstances, be a much more attractive legal target for an aggrieved parent than another individual parent administrator. So
I can understand that, what you've just described, but from what I understand, when it comes to risk and assessment of risk, the key is to understand just how likely how probable the risk is, and then what the impact might be. Now, amongst all the risks, the myriad of risks that schools face, isn't it likely to be the case that the risk is actually going to be considered pretty low and low impact?
Yeah. So, I mean, the chance of a school being successfully sued in this way is likely to be quite small. Although, you know, as I've intimated already, everything depends on the individual circumstances. And sometimes courts are, you know, they do make surprising choices, and they are keen to make a point about how data should be properly protected. But that said, you know, I do take your point. This is most likely the lower end of the risk spectrum. Perhaps more of a concern is the immense amount of staff time that a legal challenge will take up, and of course, you know, the reputational damage to the school.
And I think the reputational damage, certainly, other than, you know, setting the economic, the financial damage that may or may not come, the reputational one could be quite significant and take a while to move, I can imagine. Now, I know that the ISBA guidance has a lot of detail about these risks, and also outlines some specific steps which schools can take. What, in your opinion, though, as an expert in this field, can schools do to lower the legal risks in this area?
Well, I think the simplest thing to do is to guide parents against using WhatsApp or other similar platforms like Signal or Telegram for school-related communication in year or class groups. These platforms, of course, are fine for personal communications amongst groups of friends, and schools should obviously, you know, should not object to this. But for the reasons we've discussed, they aren't appropriate platforms where the group is more formal.
And do you think this is this guidance should be something which perhaps should be included in parental contracts?
Well, I mean, I think my feeling on that is that it's really up for each school to decide. But as long as the school issues clear guidance through whatever method they choose and do it in a consistent manner, the school has effectively removed a potential legal liability, whether it's in the parent contract or not. The other point to remember is that school staff should also be made aware of these dangers, so that they don't inadvertently, you know, to that example I used earlier, recommend parents to join WhatsApp groups or necessarily direct them towards them.
Good. I noticed you mentioned Signal and Telegram, even though we've perhaps been focusing more on WhatsApp. But do these other platforms involve similar legal risks? What perhaps is the litmus test we should apply here?
I think you should look at the main functionality of the platform. Any communications platform which is basically designed for personal use won't offer the kind of GDPR safeguards and guardrails that we have discussed, and it probably therefore isn't going to be suitable in this context. I mean, in all honesty, I haven't studied Telegram and Signal in any detail, but my sense is that they are very much focused on highly secure personal communication, would not allow the group administrator to meet the GDPR requirements that we've already looked at. So,
from a legal and compliance perspective, if these platforms aren't suitable, what else could schools suggest parents look at in order to connect and communicate? Because communication is right at the core of what schools do and have to do.
Yes, of course, and you know, I understand that the ISBA highlights two platforms in the guidance which are designed to support GDPR compliant comms between school-related groups. One of these is Facebook groups, which of course is owned by Meta, which also owns WhatsApp. But the big distinction in there is that the Facebook groups offer data controllers much more appropriate GDPR compliant controls, and therefore might enable that sort of compliance. The other is ClassList, with whom I've worked, and who had their processes specifically designed in 2017, just before GDPR came into force in the UK, to ensure that they comply with GDPR requirements.
Just changing tack ever so slightly, it's quite potential that quite possible that a number of our audience today will be based outside of the UK, indeed outside of Europe. Is this discussion relevant to what we would describe as overseas members of our association?
Absolutely, absolutely. So first of all, for listeners within the European Union, the situation regarding GDPR and legal liability is almost identical to that in the UK. Indeed, some countries such as Germany are well ahead of the UK in terms of alerting parents and schools to some of the risks that we've discussed. Countries outside of the EU, for example, in the Middle East and Southeast Asia, and even some of the US, some of the US states, some of the US state legislatures are bringing in new data protection legislation, which will often contain very similar concepts to the GDPR.
So Piers, thank you so much for sharing your professional thoughts with us today. I wonder if you've got any closing comment that you might like to make.
Oh, it's been a pleasure. Well, I know that organisations and individuals will sometimes find, and quite rightly find, data protection quite a frustrating area, where some of the regulations may seem over complex or overprotective. WhatsApp is something that most people are familiar with and generally comfortable with in their personal lives, and so I can quite see that it may seem a little nanny state for schools to start warning parents about their usage of it. However, I think we will all have seen circumstances that can all agree that WhatsApp can at times become quite a chaotic environment where people sometimes behave in a quite casual and even careless way. So you and I may be happy sharing information about ourselves and our kids in this kind of environment, but there'll be plenty of people out there who won't be. And so data protection regulations are very much designed to protect them as well as potentially you.
So Piers, thank you so much for being with us today. We've been discussing the use of social media by school parents and have referred in passing to ISBA's recent guidance on parent WhatsApp groups. If your school is an ISBA member, your bursar will have been sent this guidance in April of this year, April 22. It is a very thorough and balanced assessment of what is, of course, a complex area, and it gives some quite specific recommendations. If what Piers has shared today has given you pause for thought, please take a look at this document, which I think is generally consistent with our discussion and gives a lot more detail. It also highlights other important issues with WhatsApp around inclusivity, security, and content. If you're not an ISBA member, please contact IAPS or our IAPS Premier Partner class list, who can point you towards specialist resources that can help you. Please also note that what Piers has said today is for general information only, as indeed is the ISBA guidance, and it is not specific legal advice. This is a very technical area of law, and you should consult your own legal advisor if you have any specific questions. Thank you for watching and listening.